Welcome to the Bobby O Show. My name is Bob Opotzner. I'm an attorney in the greater Danbury, Connecticut area. I live in Richfield, Connecticut, and I have a very special show today for me, both because of the quality of the guests I have today, but of course I always have good quality guests, but also this is my 100th show under the banner of the Bobby O Show. And I did about 100 shows before that under Community Forum and also 30 Minutes, but this is very special to me because I do now, of course, the 1 hour show every week. And before I get to my guest today, I do want to call out a few names of people who have been very instrumental in the show. One is John Golgatino, who was the one who first got me onto this TV gig, and that was when I was a guest on his show. And actually the topic was collaborative divorce, which is something that we're talking about today, but I want to thank John for what he did in that regard. The first director I had was Dave King, who actually the song that you just heard is a song he wrote himself, and we've used that for the show. I also was a guest on the Marty Heiser show in this venue, but I want to thank the people who now are in charge of getting this show well organized. I have my co-directors. Thank you very much to Jonathan Capiello and Candian Tibnez. I have Helen Hedman and Michael Fager, who are also behind the scenes today, right now, and Dan Baker as well. And then also Christina Breton, who did the opening that we have. I want to thank you folks very much for the work you've done for me. I've made 100 shows, perhaps make it to 110, you never know, maybe even do more. Today I have two fantastic guests, as I said. Both of them are excellent attorneys who are involved in what we call in non-adversarial divorces. That could be either collaborative divorce or mediation. And we'll talk about that a little bit later on in the show. And they're members of a group called CCND, which we'll talk about in a few moments as well. But the whole key is to try to help people get divorced in a way that's as non-adversarial as possible. Let me first introduce Deborah Noonan. Deborah, how are you?
Good, Bob. How are you?
Fine, thank you. How about a little about yourself, please?
So I am a divorce attorney, and I've been practicing law, I hate to say it, for a very long time, but I've been doing family law for about 25 years. And about 4 or 5 years into practicing family law, I decided that I was just going to do non-adversarial divorce. So I've been doing mediation and collaborative divorce for the last 24 or 25 years. And I am a longstanding member of CCND, Connecticut Council for Non-Adversarial Divorce, and a past president.
And you're also involved in the Darien Divorce Group as well.
Yes, I'm also involved in a collaborative group of collaborative practitioners in Darien. Yes.
Great, that's great. We're kind of going to come back to you because you mentioned collaborative. There's actually three kind of models we follow in divorce practice. One is the so-called traditional model, one is collaborative, and one is mediation, and we'll distinguish those as we go through the show.
Great.
Jill Bicks.
Hi, Bob. Thank you so much for having me.
It's my
really
pleasure.
Fun to be here with you and Deb today. So you want to hear a little bit about my background, I guess?
Yes.
So I don't know if I could fight Deb to say who's been a lawyer longer, but I haven't always.
I have been.
Yeah. We've been around for a long time. I started out actually doing litigation at a big corporate law firm in New York City, came to family law after I had children, believe it or not, and worked in New York City and really had a very hard time with the litigation involving children and custody because my kids were really little and it was just so personal for me back then. So I switched over and I started working in the nonprofit world, advocating for children in the foster care system and being their guardian ad litem.
What's a guardian ad litem? I mean, I know what it is, but the audience may not know.
A guardian ad litem is a person who speaks up and informs the court about what's in the best interests of children. So guardians ad litem are present sometimes in family cases and divorce cases, and they're also present in situations where children are in foster care removed from their parents for abuse and neglect. Different roles. In family law, they typically are lawyers. Sometimes they're therapists. In the child protection system in Connecticut and all over the country, actually, you can have community volunteers do that work. So I supervise community volunteers doing that work in Connecticut. And then I came back into family law, and I started doing litigation for a firm, a big firm in Connecticut, and also knew about collaborative practice and mediation, and really started focusing my practice exclusively on that during the pandemic, actually. And now I'm on my own, in my own firm, only doing non-adversarial divorce.
Now, see, I grew up in the traditional model, which means essentially each side has a lawyer. And even though 90% of all cases settle, there's a whole different shtick, whole different feeling, and we'll get about that in a few minutes, when you're doing a case that's collaborative versus one of the traditional models that become settled. However, I have been a convert about 10 years ago, and I got the training. I first met you, Deborah, about 20 years ago when you had you were pregnant with your last child, youngest child, and I've been a convert. I think to me, in my opinion, the best way to go is, unless it doesn't fit the model for the clients in that particular case, is collaborative. I'm a big proponent of collaborative, and we're going to get into that. We've mentioned collaborative. I want to talk about the training for collaborative. We didn't just one day say, hey, I'm going to be a collaborative attorney, although some of our brethren, or sisters, I guess I have to say both of them, would say, oh, I am a collaborative lawyer. But there's a distinction between being a collaborative lawyer and doing the collaborative model.
Right.
And before we get into the statute that's recently been passed, let's talk about the training. Deb, you want to talk a few minutes about your training?
Sure.
And then Jill, get into it as well.
So when I did my training, which was almost 25 years ago, there were no trainings in Connecticut. So I actually went to Pennsylvania and trained there. It was a 40-hour training, and I came back and started practicing collaborative and mediation here in Connecticut. But now CCND, actually, we offer collaborative trainings once a year. So if anybody's interested in getting trained as a collaborative attorney, all you have to do is go to the CCND website, see when the dates are for the training, and you can get trained.
I was trained in Westport, Connecticut, I think it was, with a couple ladies from Toronto, Canada. Do you know, I don't remember the name of the person. You would probably know the names of the people.
I did their training as well.
Oh, yeah. That's where I met you, I think.
Yeah, I mean, you do updated trainings to stay fresh. So
all the
yes.
time, yeah. In fact, I go to the Darien group I belong to once a month. We're there and we present. We have people who present for us. But training is critical. The tips you learn, in fact, the other day, we do the first Wednesday of each month, I believe, our group with you, and we'll have, say, for half an hour, some session saying, hey, who has a case? Let's talk about that case. So we're always being trained, but you still need that formal training.
Absolutely.
Well, I'll say, Bob, the training is also for the other professionals who take part in a collaborative divorce process.
Good point.
So you have therapists and you have financial planners, and we'll get more into the team approach, which is what the collaborative process is. But those professionals also have to receive training. And the reason we do is because the way that you talk about issues, the things how you negotiate, is very, very different in a collaborative process than in the traditional model that you were talking about.
Yes.
We all have to kind of leave our old training behind.
Yes, it's hard. It's a paradigm shift. And if you've been practicing family law in the litigation model, it's very difficult to make that switch, but you can do it. But you definitely need to be conscious of what you're doing, and that's what the training really does. It makes you conscious of how you negotiate, interest-based negotiation versus positional bargaining. It's all of that. So it's intense training, but it's necessary.
I've done shows also with prior presidents of CCND. I had Jen Champagne on several shows, and the current president, Rosemary Ferrante, on, and so we've done a lot of these kinds of shows, presentations. I can remember one collaborative case I had in which I had the husband, and we try to ask questions to get people, what are your goals and objectives, not your position, but your goals and objectives. And the other client said, I said, what's your goal? She said, I want to get all the assets. I looked at her, the other opposing counsel looked at me, and I said, well, what do you really mean? Because you can't get all the assets. And she said, well, I reasonably want all the assets. We thought that case wouldn't, we ended up settling the case, but it was a little difficult. But the training is critical.
Yeah.
And in fact, I went to one of your trainings on May 16th of this year at Quinnipiac, where I went and saw, and there was a presentation by Dr. Christine Cocciola,
Yes.
who's been on my show twice, about coercive control.
Yes.
And in fact, in the new statute, which we'll get to in a moment, because I know Jill wants to talk about the statute, it talks about that, and I was astounded when I read, in fact, I sent Christina a copy of the statute saying, hey, you know that it's right in there, because it's a very important perspective.
Yes.
Jill, what's coercive control while we have, just briefly, just so since I mentioned it?
So the concept of coercive control comes up in the context of domestic abuse and violence, and for years and years, people thought that that domestic violence or domestic abuse had to be physical. And there's been a realization over time, I would say, that domestic violence can also be mental. And it can involve things like financial control, not sharing information, not sharing resources. That's one element of coercive control. Others could be isolating your spouse in a home. So it really broadens the idea behind what constitutes violence and domestic violence in a marriage. It's not just a punch.
There was a recent case last month or two downstate, Fairfield County, in which the control also dealt with food control. And that's why I've had those couple of shows. And when we get to the statute in a few moments, there's a clause right smack in the middle of the statute, section 15 of the statute, that talks about making sure that we as lawyers keep an eye out for those kinds of things.
Yes.
I've mentioned the statute a couple of times, but before we do that, I want to show the audience what it's like to go to an initial consultation. Most of us do initial consults with potential clients. I don't take every case. You don't take every case. You want to make sure there's a good fit involving you and the client. But part of the discussion, to me early on, the discussion with the new client or potential client in consultation format is, do you understand what your choices are? You've got to start a divorce at some point in time in court, and you've got to also get to the court system at the end. But how do you get there is a very important factor. So I was going to have you folks do an initial discussion about that, but I want to read one thing that I was advised by someone in the ethics. We have ethics requirements for the law, and that is, quote, the information that we're providing to you in this program is general. Legal questions are fact-specific, and seemingly unimportant facts can be outcome determinative in real disputes. Under no circumstances should you assume that the information in this program is a viable substitute for legal advice you would receive from an attorney that you engage in a specific issue. In short, we are providing general information and not legal advice that you can rely upon, unquote. Now, that doesn't mean we're going to give you, in the audience today, ridiculous, not relevant information, but just understand that your facts, and so many phone calls come in from new clients, I have a simple case, no problem, don't worry about it, it'll be fine, right? Those are the words that worry me. So just understand what we're talking about today is our view overall of the law, but it's not necessarily going to be your case. Having said that, protected you ethically from malpractice insurance.
Thank you, Bob.
You're welcome. Let's talk, who's going to be the lawyer and who's going to be the
I think Jill's going to be the lawyer and I'm going to be the client.
Okay, so let's listen to see how your discussion would be an initial consultation for what may be a collaborative case.
Okay. Deborah, thank you for coming in to see me today. It's nice to meet you.
You as well.
Let's talk a little bit about, just give me some basic information about your situation, because I want to help you understand that there are a number of ways that you can go through divorce, and it depends on your circumstances which path might be the best one for you.
Okay, so I've been married about 20 years, almost 20 years. I have 4 children. I have a daughter who's in elementary school. I have 2 sons who are in middle school, and I have a daughter who's in high school. I have been a stay-at-home mom for the last 15 years. I worked for the first 5 years. And then when I had my second child, we decided that I would stay home. And so I haven't worked outside of the home for 15 years, but I have definitely done, the majority of the child rearing. My husband is in finance, and I'm embarrassed to say this, but I really don't know much about our financial situation. I mean, I'm smart, but I've just been really busy with the kids.
Of course, and you know what, Deborah, that is so common. I can't tell you how many people come into my office and say exactly what you're saying. So there's no reason to feel like embarrassed about it.
Well, thank you. So I just haven't really involved myself in that arena. So I don't know, he does the tax returns, I sign them, but I really don't look at them. So I'm not even quite sure what he makes, and I'm not quite sure, I mean, I know we have a house, but I'm not really quite sure what our assets are. So I'm a little nervous, because I just, I feel like I need someone there to guide me and make sure that whatever outcome we have is fair to me and to him. I don't want to rake him over the coals, but I want to make sure that the kids are taken care of, and that I'm going to be financially okay.
Well, first of all, thank you for sharing that with me. It's very hard to talk to a strange person that you're meeting the first time and giving all this like very personal information. But what I hear you talking about is what your goals are and what your interests are and what you care about. And I think it's really important for you to know that there's more than one way to get divorced. The process of divorce can be so different depending on what path you choose. And personally, my feeling about divorce is, especially for someone like you who has 4 children, your daughter's still pretty young, you're going to be connected with your husband after the divorce forever through your children. You're also going to be connected financially with him. And so a lot of people believe, okay, just have to get to the end of this divorce and then it's over, it's fine. That's not going to be your life. Your life is going to be connected forever with this partner of yours, and your relationship is changing from married people to co-parents. And so, the traditional model of divorce is set up and was set up mostly for people or companies or for strangers, people who don't necessarily have that ongoing connection. And people have heard someone's the plaintiff and someone is the defendant, and you go to court and the judge decides. And that system works in certain cases, but my personal feeling is that it's really terrible for people who are doing what you're doing and having to do, which is separate your family, separate your finances, and figure out how you're going to parent your children together. So there are a couple of other models that some people have heard about and some people haven't heard about. One of them is mediation. Have you heard of mediation?
Yes, I have.
What do you know of mediation?
That my husband and I would sit down with the mediator, and that they don't represent either one of us. They're neutral, and they're there to help us address the issues, I guess, that we have to address in order to finalize the divorce. And I have heard that we each should get our own attorney to sort of be there to make sure that we're making good decisions and that we understand what the implications are for those decisions, but that they're not like in the room with us. It's just my husband, me, and the mediator.
Yeah.
Can I throw a question if I'm a client as well, potential client?
Sure.
Attorney Bicks, my spouse has told me that if I go for a divorce, he or she is going to keep everything. He's going to be belligerent. It's going to be difficult. I'm afraid to tell him or her that I want to do this process. How do I tell my spouse that I want to A, get a divorce, and B, I want to do it in the quote collaborative model, unquote? How do I handle that?
Oh, that's a great question.
Am I still in the role as the?
We're going to switch roles, but I just want to.
Yeah.
I want to get that point
Yeah.
out because it's a question that comes up.
I think that can I hold that question for a second, because I would like to talk to Deborah first about another process called the collaborative process. And the question you're posing comes after that. Okay, I like this process or that process. How do I talk to my spouse about it? It's a huge question. But I wanted to, Deborah has a really good understanding of mediation, and some clients do, and some people who walk into my office, you know, kind of have heard about it, don't really know. The downside for mediation could be someone like Deborah who is coming saying, I don't really know the finances and I don't really understand them. And so that's why for her, I would really want to make sure to explain the collaborative process, because that offers a little bit more support than mediation. So let me ask you, Deborah, have you ever heard of the collaborative process?
A little bit, but I'm not quite sure I understand. To be honest, I've met with other attorneys, and they'll tell me that, you know, they're collaborative, that they settle most of their cases. So I'm not sure if that's what you mean by collaborative, or if there's actually a process called collaborative.
Oh, that is such a good setup, Deborah.
Deborah did a good job setting you up. They must have talked a little bit beforehand.
Yeah.
We didn't actually.
No, we didn't, but this is classic. It really is
Yeah,
classic.
the questions you're hearing, folks, are what come up.
This is real life. This is what people come into our office asking all the time. And the reality is, as you kind of referenced in the beginning, Bob, is most of these cases settle, meaning that there's an agreement, and people don't, even if you're in a litigation or a traditional process, you come to an agreement. And what we're talking about is, how do you get to that agreement?
Right.
How do you get there?
Which is critical.
Right. That's the whole thing. I mean, that is the whole thing.
That's
because
the whole Megillah.
Yes, in
The
fact,
whole Megillah.
you said 10% of cases don't settle. I've heard I think it's less than that, actually. I think only 2% of cases actually get in front of a judge for a full trial.
It's a small percent.
Right.
It's a very
and so
small
the question
percent.
is, how do you want to get there?
And how are you going to impact upon your family?
Yeah.
Exactly. And after the trial is over, right?
Yeah.
Then what does your family look like? What is the dynamic after you've, you know?
I had a very hotly contested case many years ago, and the parties fought about whether today is Thursday or
And
Wednesday.
they probably fought for 20 years after that. They
but-
get to the trial, and then they appeal it, and then they have fights post-judgment. But so Deborah was saying that a lot of attorneys say, I'm collaborative, I settle my cases all the time. And that's true. And I wish the collaborative process had a slightly different name for that reason, because it's not meant to be a collaborative process, meaning an adjective describing a noun. Everybody's nice, we all get along, it's rainbows and unicorns, and it's not. It's hard. No matter what process you're in, it's hard. And so what I like to say and talk about it is that the collaborative process is really a team approach to your divorce, where you have more support than you would in a normal mediation process, because we bring in a mental health professional who is very familiar and can educate both parents about the developmental needs of children, and talk about parenting and co-parenting now and in the future, as opposed to fighting, well, I want 50-50 custody. No, you can only have 85% and I want 35%. It's ridiculous.
By the way, that's more than 100%.
I know. But that's
like
what happens all the time. They
like
fight
you're
over
not
like,
good at math.
and they want over like everybody wants the children like more than the children can even be with them. So it's ridiculous, and nobody's talking about, well, who's doing the driving and who's doing the homework and who's doing the feeding and the food shopping and all that. It's my time with the children. So in a collaborative process, you're not talking from that perspective of percentages. You're saying, like, who are your children? You have 4 children. Who are they? What are their interests?
But what if we don't feel like we need this person? I mean, the one thing that my husband and I are on the same page about are the children. You know, we share sort of broader child rearing views. We don't really argue about the kids. So tell me why I would need that person as part of this team? Because it's sounding, I'm just getting a little nervous. It sounds like it could be an expensive
Yeah.
process and a little
Yeah.
cumbersome.
Yeah. Well, so let's just say that the collaborative process has the potential to offer these additional professionals. It's not required, and I'll talk about what is the hallmark of the collaborative process in a second. But the other person that maybe would be beneficial to you that we could bring in is a financial planning, divorce financial planner professional. Those people do the role that 2 lawyers usually do in a litigation process. It's very streamlined, very efficient. They collect all the financial data that you need to make decisions and explain it. So in a situation, Deborah, back in role, where you are someone who isn't familiar with the finances, or your finances are complicated and you have lots of different kinds of investments that your husband invested in a hedge fund or whatever it might be, you'll get education about what those are.
Let me just clarify something, because the audience, you're more sophisticated than some of our viewers will be. In the divorce process, there needs to be an agreement, if you're going to settle it, that the court finds is fair and equitable. And there'll be financial affidavits exchanged by the parties, and so financial information is important to the process, as we all know.
Yes.
And therefore the question is, how do we as lawyers who are not trained as psychologists to be involving the kids necessarily, or the financial mavens, the most knowledgeable people, and so you need people to help out. And if you talk about the costs that Deborah raised, the issue would be if you have one neutral who truly is neutral and does these analyses, it saves money, and that's where that would come
Right.
in. I just want to clarify that for
And
the
thank
audience.
you.
And I also just want to clarify too, because we use the term financial planner. So I just want to make it clear that
Sure.
they're not planning. It's not like when you go to a financial planner and they say you should be putting this much aside for college and this much aside, invest in this stock. It's really a financial sort of analyst advisor who's getting collecting all the financial data, so that then can be presented to both parties to say, here's your financial landscape, and how are the two of you going to divide these things up going
For
forward?
example, let's suppose the wife owns a gas station, and part of the assets in the case are the value of the gas station. Instead of having two people analyzing the value of the gas station, which might be relevant to the divorce process, one person does it, goes through the numbers, and says, here's the true analysis I've made, and then you can discuss that, and that's what you're trying to talk about for those. And notice the wife is one who owned the gas station.
Yes,
I'm surprised
I did notice that.
Yes, I'm surprised that you picked a gas station
I
as
don't know.
the asset, but okay.
I want to.
Can I just say one thing?
Well, one second.
Okay.
Because what I don't want to do is to do a monologue of the whole thing. I want to get into different points spread out for the people.
Yeah.
There's a concept called client-driven and client-focus.
Yes.
In terms of the collaborative process. Can you talk about that, Jill? Because I think it's important for people to understand.
Yes.
This is one big difference, I think, in collaborative versus other models.
Yeah. But I would like to say one more thing, Bob, because I honestly think this is the most important thing about collaborative.
Bingo, go ahead, do it.
If you go to a lawyer who says, I'm collaborative, I settle my cases all the time, and if it doesn't settle, we can still go to court. You are not in the collaborative process.
Correct.
So the most important feature is, yes, you have this team, but just like mediation, you are protected, you should be protected from having the participants, the professionals in your process, then showing up in an adversarial court proceeding.
Absolutely.
Yeah, so can I just dovetail off of
This-
that?
you should see the three of us were having milkshake at Shake Shack.
Yeah.
Go ahead.
So what Jill is referring to is what we call the disqualification clause. We call it a DQ clause, but it's a disqualification clause that is found in the participation agreement that all these professionals that Jill is talking about, we all sign. The two attorneys, the parties, the financial person, the mental health person, we all sign a participation agreement that not only outlines sort of the protocols, which Jill's going to talk about when she talks about the UCLA, but also says that if the collaborative process breaks down for whatever reason, and the parties decide to leave the process and go on to litigation, that all the professionals are contractually barred from following them into the litigation process. And that disqualification clause is important for two very good reasons. One, it keeps people at the table, right? So you have a very emotional meeting, emotions are high, someone gets angry, they stand up and they say, come on, Jill, we're leaving and we're going to go to court right now and file X, Y, and Z motion. Well, you can't, because you can't take Jill with you. So it sort of makes people think twice before they leave the process, because they know they're going to have to start all over again with new attorneys. And not only do they start over again with new attorneys, but all of the work product that was created during that collaborative process goes away.
And the DQ clause, and I don't mean Dairy Queen, the DQ disqualification clause, I would say was probably one of the most controversial aspects, especially when I talk to clients about the collaborative process. Jill and I have had discussions, you and I had discussions about this, and that is that if you're going to, and you mentioned the participation agreement, if you're going to do collaborative, then you have to say the DQ clause is in. But some people say, well, you know, that's not fair, because let's suppose that it's going well in my direction and my spouse doesn't like that, then that spouse can blow up the agreement and we finish, and it could end the collaborative process. And so some people were doing something called cooperative, which was no DQ clause in, but the statute, which is adopted effective October. I'm getting segued into your statute.
Well, I'm not done yet with my thought, but go ahead.
That's right. You guys can understand. I think I'm the host, okay? Okay. I'm Nicole Wallace here, and you're, Attorney Weissman and whatever. So we only have 5 hours for the show. But that's something that has now been taken care of by the statute we're going to get into. But I want to give you your chance. Go ahead.
So I wanted to say that the second reason why the DQ clause is so important is because it affects the tone and tenor
for sure
of what's happening in the room. If you are sitting at a table with your soon-to-be ex-spouse and their attorney, and you know in the back of your head that there's a slight chance that if this all blows up, we're going to be in litigation, and this attorney may be cross-examining me on the stand, I'm not going to be quite as open,
correct,
quite as engaged, quite as committed to the process if I know that there is a possibility that that person could become my adversary. And so if you know that they will be disqualified, I think it just brings a different sensibility and a different tone and tenor to
I agree with
the
you in that
meetings.
regard, but that's like anything in the law. The law is not black and white. It's always gray, and you have to figure out what's the weight and what's the balance. And when I would talk to clients about the DQ clause, I say, look, I think you're better off for the reasons that you mentioned, but it's not black and white. But I want to transition here because we are going to get a few points across, and that is, how do you decide, I'm going to give each of you a minute on this one, how do you decide whether or not a case is one that, I just don't think this is a case that's going to work, or rather you might say, the client doesn't think it's going to work for collaborative. How do I explain to the client that it will work better for their system? So let's go a minute for each of you on that as to how you decide whether a case is one that's collaboratively appropriate and maybe one that's not.
So I really feel, and this sort of ties into what you were saying about the difference between client-focused and client-driven. I have to assume that once I've explained the different processes to my client, if they really believe that the collaborative is not the right process for them, I may follow up with some questions and ask why they think that, but at the end of the day, it's their decision. In terms of my assessment, I really believe that almost all cases can be settled through collaborative or mediation.
I agree with you.
And so there's very few cases that I've had where I've thought, I don't think collaborative is the right fit for them. Very, very few. So I think that if both parties, I get this question all the time from clients, how do we know this will work? My answer, not to sound glib, but my answer is, if you want it to work, it will work. If you are committed to staying out of litigation, if you're committed to being the architect of your own agreement and not having some judge who doesn't know you from Adam make decisions, then the process will work.
And by the way, that case I was telling you before about the people who are very difficult, the kids end up going to college way in the West Coast. Because why? They want to get away from it. What are your comments on what Deb just said?
Yeah, I completely agree with what Deborah said, completely, and what you said as well. And I think once you educate people about what litigation really is, nobody wants that. It's super expensive. It takes a really long time. Most people don't get what they think they're getting, which is the court saying what's fair, because they don't go to trial. Even in a litigation process, the way settlement comes about is people run out of money. They can't pay their professionals anymore, so they have to settle. They can't afford the trial because they've spent all their money to that point. They don't necessarily get all the information they think they're going to get. In fact, as a litigator, I found it so frustrating that you would have months and months and months of fighting over what documents get produced, and a lot of times they don't even get produced. So there's a lot of magical thinking about what the litigation process is. So when you educate people about what that looks like, most people don't want it.
And one of in the collaborative model, there are several experts who get involved, and one is a coach, a mental health professional. And sometimes there's an old book called Getting to Yes, from when we were kids, that book. And sometimes I don't want to give her that. Well, why don't you want to give her that? And it comes out that my grandmother Sadie gave it to me and it's mine. And sometimes if you have in collaborative, it's easier, in my opinion, in a tough case, to get to, well, now I understand why you want it so badly. You know what, now that, sir or ma'am, that you really want it, I'll take this candelabra versus that one. So use them as a professional, even though there's more people involved, perhaps in the collaborative, you may find it more economical because you can help. I've had cases, very difficult cases. I had one particular where a child was, unfortunately died in the marriage. And I brought in Jennifer Champagne. We brought in Jennifer Johnson Hurwitz, was my opposing counsel, very good lawyer. And we brought in Jennifer Champagne, and there were times we just said, Jennifer, take over.
Yeah.
Jennifer would bring her oranges and her cookies and whatever. And so we as lawyers, and this is the thing that some lawyers, when I first got involved in collaborative, would say, oh my God, we can't do collaborative, it takes away our control.
Yeah.
And the answer is, when I have cases where there's discussion about parental contact of kids, custody visitation, I will often recommend, and counsel I think usually agrees, let's let the mental professional go without the lawyers. We don't need to be there at that. Any comments about anything I just said? You can say yes, no, maybe, whatever.
I agree exactly with what you said. I mean, that is their area of expertise. We as lawyers are not experts on child development and all of the psychological and emotional components of childhood. I mean, we all have children, and so in that regard we do, but that's not our area of expertise. So why wouldn't you let someone who knows what they're doing do that part of the case for a lot less money and probably doing it more efficiently and more effectively? So that is, one of the cornerstones of the process, is bringing in this full team, this complement of professionals to do a better job than just the attorneys could possibly do on their own.
Before I get to the statute, Jill, you get the last comment.
Yeah, because Deb, in her role play, because she gets that question all the time. We get along. Why do we need? In addition to what Deb just described as the parenting advice, I think sometimes the biggest impediment to coming to an agreement in divorces are the emotional components. Like, people are scared. They don't know what the future looks like. They don't understand. The decisions are too big. So those emotional impediments are best addressed by the role of that mental health professional or coach. Sometimes they're called a coach for that reason, to help people through those hard decisions that have to get made.
One of the tough things we often have, I find, is when someone says, this is a 4-letter word coming up. My friend told me that. And how often have you gotten that one? A lot, right? And I'll say, you know what? Let me call your friend right now. I don't know if you've done that. And I've done that. I said, let's call your friend right now and find out. And in his case, he only had to pay $2 a week in alimony. You only have to pay $3. So I called a friend and I said, wait a minute, how much did you make? Well, the person made half of what you're making. But I mean, that's why this kind of process, collaborative model, for example, is better because you can make those phone calls, and I've done those kinds of phone calls. I want to transition because I don't know.
Can I just say one thing quickly?
First of all, there's never one thing, but go
Yeah,
ahead. For any of us, for any of us.
the other benefit to having the mental health person is sometimes the lawyers are the problem. Even the collaboratively trained lawyers. I mean, we're human beings. We get into a room, and sometimes you have a wonky meeting. You know, some things just don't feel right.
You mean I'm wrong?
You know, I mean, there's
Yes.
a certain dynamic
You are right.
between the lawyers, and the mental health person keeps you honest. You know, one of the things that Jill didn't get a chance to talk about, because I probably interrupted her, is we sometimes have meetings. The professional team will have a meeting before we have our full team meeting to talk about an agenda and what's going on with any one of the clients, and then we debrief. And sometimes during the debrief, the mental health person can say, yeah, what was going on there between the two of you?
Sure.
And you have a chance to talk about it, and it rights the ship.
I've done cases where I called the opposing counsel and said, by the way, for the meeting we have, we usually do an agenda, so you sort of know what's going on. We do minutes of the meetings, exchange them. But I'll say, I've done this. I've got a tough issue to raise on tomorrow's meeting. And I want you to know about it so that you can hear about it and you can prepare yourself, whatever. So it's
Your
not
client.
like, it's not like, you know, it's hidden ball trick. It's I want to tell you in advance,
Yeah, right.
which you don't as much get in the non-collaborative.
Right.
Comments about that before we go into the statute, which I think we might get into
Well,
anymore?
that's the magic sauce in a collaborative process, that you have these other neutral professionals helping, and as lawyers, we're taught in law school, you know, you have to advocate zealously for your client. Your client hires you. They want you to fight for them. And so it really is a very different role in a collaborative process. Yes, you have to help your client and advocate for them, but if the lawyers get stuck in advocating for what their client wants, we don't get to that, well, what is the solution that will be acceptable to both of you, that meets most of your needs, not all of them, like your client who wanted, you know, 100% of the assets.
The other side.
Yeah.
And by the way, in that case, we broke off and we didn't meet for a couple weeks and we talked about things, but communication is critical in life. I want to get to this statute because a lot of the discussion, the training, you said 25 years ago, whatever, there was no statute at that point in time.
Correct.
It was a new model. And effective October 1, 2025, there's a new, Connecticut has a Uniform Act that we're involved with, and you two ladies were involved in the process, as was CCND. Did we put the CCND chart up? Jonathan, can you put the CCND chart just so we make sure we have it for the audience? And while we're getting that, here it is. This is CCND, the Connecticut Council for Non-Adversarial Divorce. We went to the meeting about a month ago where Sidney Horowitz got the annual, the Lifetime Achievement Award. He was a mental health professional. But you know, in this situation, we need to try to follow the statute now that helps us use the things that the tricks we've had over the years. So I'm going to let Jill go first.
Sure.
Jill, tell us how procedurally, not the whole spiel.
Not the whole spiel.
How do we get the statute passed in October, effective October 1, 2025?
Well, basically, it took a lot of education and coalition building, and at the end of the day, it was like a 10-year process, I think.
At least.
Of getting all the different organizations, the Bar Association, the different sections within the Bar Association to approve it. The American National Bar Association has approved it. So there was just a lot of work all along to educate the legislators as to why, and lawyers and other members of the community as to why we needed it. And because it was being done, the collaborative process was happening. We didn't have a statute. But what the statute does is it debunks all the myths. You can't call something a collaborative process anymore under the law if you don't sign the disqualification agreement.
Education was critical. I was in the executive committee and still am, the Connecticut Bar Association Family Law section, and there were a few times that Deborah would call me and say, hey Bob, I know it's on the agenda. Remember you call me, it's on the agenda for our meeting, have discussion, and once people understood and had their questions answered, people being the lawyers, the judges, everyone got behind it, and thank God we now have a statute, and I think it might be worthwhile to talk a little bit about some of the critical elements that you all think why that statute's very, very important, and how it helps our clients to effectuate a divorce in a proper, a less adversarial way.
Well, I gave the first one, so Deb, you go ahead.
Well, there's a lot of good things about the statute. I think, and Jill and I were talking about this last couple of days ago, that I think it gives legitimacy to the process. So everyone knows about traditional litigation. If you ask people, how do you get divorced, they'll tell you, like what you see in LA law, or, if you've been through a divorce, or your sister or brother, that's what they know. And when you start talking about collaborative divorce, it's sort of like, well, what is that? Is that even a real thing? Is that legitimate? So it helps the consumer, the end user of the process, to have confidence and faith that this is a real process, that there's a statute behind it that delineates what you can and cannot do. And I think that is one of the biggest benefits of having the UCLA.
Jill, one problem we used to have in the past when collaborative was getting more and more in vogue is that some of the judges who are, let's say, a little bit older, now that we're our age, older is 97, but no, seriously, when judges were older, didn't really know the model, and we had certain rules that if you didn't advance a divorce case in the traditional model by a certain date, you get called in and get in trouble, not because the judges weren't doing their job, but because Hartford has statistics they had to fulfill.
Right.
But now there's a statute that gives credence. In fact, Judge Ahrens and others spoke at that meeting we had with Sydney about how it's easier for us.
Yeah.
So talk about a couple of things that make it easier for us as collaborative attorneys to get the process done for the betterment of our clients.
Right. So now the collaborative process is actually built in to the court process. And lawyers in the courts run in certain ways, and there are all these rules and time periods and court status conferences and things that the court requires you to do. Under this new statute, if you file a notice with the court that you're in a true collaborative process and you've signed an agreement, and the statute says what has to be in that agreement, including the DQ clause, the judge will put your case on hold and not call you in and not ask you for status reports. They know there are no motions coming. So it's on a different track within the judicial system, but yet you get the protections that the judicial system can offer, like a certain time period in which everything should be resolved. That's still going to hold. You have, and it's usually like a year. Other things that are very technical, the automatic orders, which are put into a place when a divorce starts. We used to incorporate that into our agreement, but now you get the court-ordered protection. So there are things like that.
Or you can also choose to limit the discovery process also in the new statute.
You can also delay filing the case
Yes.
also, but
Yes.
for various reasons I don't think we want to get into.
that
it.
gets a little bit-
There's
No, it's a good point, but I don't think we want to
Yeah,
get into
no, I
that
agree.
particular point.
It's just that the statute allows you now to do it, where before it could have been problematic.
Can I pick out a couple of sections that I like?
Sure.
And I'll let you do the same.
Yeah.
Okay, I'm looking at section 14 of the Public Act, and it talks about that lawyers who are doing collaborative divorces have to provide information to the clients as to why it is they're better off with the risks and rewards of using collaborative process. Talk about that a little bit. I think it's a very important clause because it gives making sure that the clients understand what they're getting and not getting. Who wants to take that one?
I'll do it.
Okay.
Well, I think it's sort of, we've already talked about this, which is you sit down with your client, and when you explain the collaborative process, you have to explain to them that there is the risk that if the collaborative does not work, they have to start all over again with new counsel, and that they lose all the work product that's been created during the collaborative process. That's a big risk. Personally, and I think Jill, you would agree, I have very few collaborative cases that don't make it to the end, but when they do fall apart, that's a risk that the client needs to know, that they could have spent a lot of money, a lot of time, and now they have to start all over again.
But I'm going to
Jill?
say that, that also happens in litigation.
Absolutely.
I've had a lot of people come to me, I'm not really getting along with my lawyer. We're far down the road, can you take my case? Some people go through their divorce and have, multiple litigation attorneys as well.
What I'll do is if someone comes to me as a second opinion, and I've told clients, if you're not sure what I'm saying, go talk to A, B, or C to see if I'm doing it right. But if someone comes to me and says, well, my lawyer's not doing a good job, I'll say, tell me specifically what it is your lawyer is not doing correctly. And I'd say 95% of the time, or close to it, I'll say, you know what, I might do the same thing. And so we as the second lawyer need to discuss
Oh,
that.
yeah, for sure.
Another provision, we have only 5 minutes left, believe it or not, in this show.
Oh, my gosh.
We are going to do another show, right? Not today, but another show.
Yes.
There's something called coercive control, which we talked about. And in the new statute, my eyes popped out when I read it the first time about the fact that we as lawyers have to be looking to see and make sure that there's not coercive control in the cases, and if there are, we have to take special steps. Jill, you want to talk about that a little bit?
Yeah, so, that, I'm so glad you picked that out, because frankly, that should be something every lawyer works through with
Amen.
their client,
Amen.
right? And now there's, a law that says, attorneys, you need to screen for this. You need to ask questions about it. You need to understand it and be clear. That doesn't mean you screen a client out because there's domestic violence or coercive control. In my personal opinion, most people in situations like that benefit from the collaborative process and are actually destroyed in a litigation process because the coercive controller in that relationship is in a war and they like that environment, and the person who's controlled tends to be less, energized by conflict. So I think what the statute does is educate professionals generally that this is an issue we have to take seriously and figure out how we're going to deal with it.
And your point was well taken, because in fact I said to both of you ladies when we had our prep show, which I always do, and that is, why isn't that provision in the traditional model? And I'm really attuned to it because Dr. Cuccelli, as I said before, I've had her on the show twice about coercive control, and I'm now more attuned to it. I wish I'd been more attuned to it,
Sure.
but that's where our education is
Yeah,
involved.
yeah.
And we have to make sure we understand that.
Yeah, so sort of to segue off of what Jill just said, and I know we don't have a lot of time, but sort of the myths about collaborative. And one of them is that if you have domestic violence or intimate partner violence or coercive control, which is a subcategory of domestic violence, that they should not be in the collaborative process. And I personally believe that that is just the complete opposite.
I agree with you 100%.
Right? I mean,
100%.
you have a dynamic that's based on power and control, and what do? You put them into an adversarial system that's based on power and control versus keeping them in a collaborative process with trained professionals who are trained in trauma-informed therapy, who are trained in domestic violence. They can create a safe space. There's protocols that you can use in collaborative where you can have them in separate rooms. You can do virtual.
And the thing is, if my client's the coercive person, you can be rest assured, and I know the same would be true if you guys are there in that role, I might say to my client, hey, wait a minute. You can't talk to your client, to your wife or husband that way. You need to show respect. And we actually, in my collaborative things, we talk about respect in the, I'm sure you do also. Well, we have, because I've had cases with you guys, but in the respect of the process. And it's very important. So I think you're 100% correct that sometimes the harder case is the one you really need collaborative. You were going to say something, Jill?
Well, I love that Deborah brought up the myths, because there are a couple of other myths about collaborative that I think we should get to. And one is that somehow the law is different if I choose this process or that process. And no, it's not. The law is the same. We're just talking about how do you get to an agreement, which most people do. And the other thing which ties into this whole idea of coercive control and domestic violence is people think, well, I can't be in a collaborative process because we're not really collaborative. We don't get along. We're not amicable all the time. And so it's important to understand that you don't have to be amicable all the time.
I'm going to give each you guys 30 seconds or 45 seconds, more or less, to give a wrap up of anything you want to say about the collaborative process. We'll start with you, Deb.
Sure. Just that now that we have the UCLA and it is, by the legislature, they've got the legislature's blessing, I think people need to look into that process as a very viable alternative to traditional litigation, that it is, you're going to get a team of professionals who are dedicated to helping you shepherd you through a very difficult process, and you're going to end up with a better result.
Jill?
Yeah, so just piggybacking on that, the result that you end up with is more durable. There are less arguments about it after the fact, and your team can stay in place. Your co-parent counselor can be available after the divorce is over to help with
Final thing I want to say to you is
Yeah.
CCND. How does someone find CCND? Because in CCND, it lists all of our names and what we do. How does someone find CCND?
It's gooddivorcect.com.
gooddivorcect.com.
Right.
I want
Yeah.
to thank these two wonderful ladies for this discussion about the collaborative process, and also I'm honored to have you guys be my 100th show.
Congratulations.
Yes.
This has been Bob Opotzner with wonderful guests, Jill Bicks, Deborah Noonan. Thank you very much. Shalom.